Is there a danger of bringing in a medical expert who is retired from the practice of medicine? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is yes, there is a risk associated with bringing in a medical expert who is now retired from the practice of medicine. You see, in a medical malpractice case, we are required by law to have a medical expert confirm, number one, that there was wrongdoing, number two, that the wrongdoing caused injury, and number three, that the injury is significant or permanent. And now, when the medical expert comes in to testify, they will be asked lots of questions about their credentials. And one of the credentials is, doctor, are you actively practicing in the state of New York? Oh no, I'm not actively practicing. I retired a number of years ago. Now, why is that a danger? Why is that a risk to us if we're bringing the claim and we bring in this retired medical expert? Well, one of the things you should know is that just because a doctor has retired from the practice of medicine doesn't mean he's not knowledgeable, doesn't mean he's not an expert in his field of medicine. However, what it does mean is that he might be out of touch. What it does mean is that he might not have performed this particular surgical procedure in the past 10 years. What it does mean is that he may not be up to date on the most recent techniques and the advanced techniques, even though he may have read it in a journal. And now here he is giving expert medical testimony and conclusions about another doctor violating the basic standards of care because of something that the other doctor did or did not do. It is critical in every single malpractice case to try and bring in a medical expert who has the same type of qualifications as the doctors that you are suing. We want to get a doctor who is board certified in the same field of medicine. We want to get a doctor who does these same type of procedures, who has the same level of experience, if not more. Bringing in a retired medical doctor is certainly possible. And we can show to the jury that this doctor is well published, that he's well regarded, that he's an expert in his field of medicine. But when the defense attorney gets up to cross-examine him and ask him about whether he's still practicing and when the last time he had performed these procedures, it's actually pretty devastating to have him say, oh, I haven't been in an operating room for 15 years, or I haven't been reading and interpreting x-rays for the last 12 years. Why is that? Because now the doctor is perceived to be out of touch, even though he may still be very knowledgeable and be an expert in his field of medicine. It is always preferable to have a doctor who is experienced in this area of medicine, of the doctor that you are suing, and it is always preferable for the jury to be able to compare apples to apples rather than someone who is long retired and now giving expert medical conclusions compared to a doctor who is actively in the trenches every single day, seeing this day in and day out. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice case leading into trial. If you're contemplating bringing a lawsuit and your matter happened here in the state of New York and you have legal questions, what I encourage you to do is pick up the phone and call me. You know I answer questions just like yours, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.